Okay, we're back. I hope you've had time to think about Pierson v. Post and how you would decide the case. What makes this such a great case is that when it went all the way up to the highest court of New York State, it's just a historical and legal tour de force. They cite international legal scholars such as this one guy known as Puffendorf. They cite the ancient Roman law going back to the 5th century AD in the Institutes of Justinian. He was a emperor of the late Roman Empire who decided to recopulate and codify all the maxims of the Roman law. They cite English legal treatise writers such as de Bracton, and it's just a tour de force. And what's cool about this opinion actually is there's going to be a divided opinion. The majority is going to say, you know what? The fox belongs to Pierson. Why? Because he has physical possession. He was the first individual to have physical possession of the fox. The dissent is going to vehemently disagree and say, well, no, that's not fair. Post was actually pursuing the fox, expending a lot of time and effort to capture the fox. And so we don't want this decision, if we were to rule for Pierson, as the majority is doing, that's going to reward strategic behavior. That's unfair at the end of the day. And so you have these two great opinions. And even to this day, right, when should something be owned? Think about your previous assignment, the Big Cat Public Safety Act, which, if enacted, would ban the ownership of wild animals in the United States. Big cats like tigers and leopards and lions, right? So this issue of ownership, right, and what it takes to create ownership. The deeper point is this. Notice that the majority opinion is trying to adopt what lawyers would call a bright line rule. Possession. Who's the first person to physically grab the fox, take possession of the fox? The advantage of that rule is that it's very easy to apply and workable. Now, granted, there may be disputes and testimony, you have to get into the credibility, but it's a workable rule that's easy to administer. The dissent, though, favors more what lawyers call a standard. Let's look at the effort expended in pursuing, in this case, the fox. So the idea is how much effort, right? After a certain point, if you're just doing very little effort, maybe you're about to go on a hunt and you buy all your hunting supplies. Is that enough to say that, you would eventually catch a fox? Probably not, right? You actually have to go and identify an individual fox. But when you have a general standard like that, that could make it more difficult to apply that standard in future cases. And so a lot of times, now Pierson v. Post, the court ultimately decided, at least the majority did, with a bright line rule. But one of the things you see when you study a lot of these common law cases, even modern cases like Yates versus United States, where courts have to interpret the meaning of words, is, okay, how should we proceed as a court? Should we go with a simple bright line rule, or should we go with a general standard? All right, in our next video, I want to talk about contracts and a very interesting case that's in your textbook, the Leonard versus PepsiCo case. And we'll talk about, of course, Joe Exotic's reward offer. See you soon. Bye-bye.